Due process is protected in two different places in the Constitution. It's protected in the Fifth Amendment, where it says the federal government cannot deprive a person of life, liberty, or property without due process of law. And it's protected in the 14th Amendment, where it says, likewise, a state cannot deprive a person of life, liberty, or property without due process of law. The courts have interpreted due process as having two components. One, they've called procedural due process. The other, they've called substantive due process. Procedural due process is if the government is going to take away your life, if they're going to execute you for capital punishment, if they're going to take away your liberty, they're going to lock you up in jail. If they're going to take away your property, they're going to fine you or confiscate your car or your property. It cannot do so without procedural protections, and the most typical ones are notice and the opportunity to be heard. In other words, the right to contest it, to make your arguments, to in a proceeding or a court of law, make the case as to why your life, liberty, or property should not be taken from you. That's procedural due process, unquestionably protected in the Constitution, both vis-a-vis the federal government and vis-a-vis the state and local governments. The second concept, substantive due process, says even with all the process in the world, even with a full trial, even with notice and the opportunity to be heard, there's some rights that they just can't take from you no matter what. And that's called the substantive component of the due process clause. What Justice Thomas is saying, and what a lot of scholars have said, is that substantive due process is a made-up concept.